Hello, welcome to this Regulate course on the protection of personal data in the European Union as regulated by the General Data Protection Regulation. My name is Nicoleta Cherciu. I am an affiliated researcher with the European Center on the Regulation of AI and Robotics, EURA, and I am also a private lawyer. I work with technology companies and I assist them in all technology law-related matters, including compliance with the GDPR. Today, we will be discussing on the evolution of personal data regulation in the EU. Then we will look at the GDPR's material and territorial scope. We will also take a look at how we can distinguish pseudonymized data from anonymous data. We will tackle the risk of re-identification of data subjects. And then we will finally conclude with the principles provided under the GDPR for personal data processing. Now, personal data protection has emerged as a concern since the late 20th century, at least in Western societies, with the advent of new technologies capable to process data at large scale, given that such processing is indicative of individuals' characteristics, desires, fears, beliefs, so on and so forth. This means that personal data protection is strongly connected to one's privacy and one's private life, which is why it has emerged as one facet of the fundamental right for respect for private life and family life, as it is regulated in Article 8 of the European Convention of Human Rights, which has been adopted in 1953. Thereafter, in 1981, the Council of Europe Convention on the Privacy of Individuals has been adopted and enacted, the so-called Convention 108, which provided for more clear rules on how personal data should be collected, used, processed, and stored. However, these rules didn't afford enough protection for individuals in the European Union, which is why in 1995 the European Directive on the Protection of Personal Data has been adopted, and then later on in 2002 the e-privacy directive has also been adopted, which provides for personal data protection rules in electronic communications. These two European pieces of legislation have proven to be efficient. However, it has been shown and found, including in studies carried out by the European Commission, that they didn't create the desired level of harmonization at EU level. This is because directives need to be transposed into member states' laws. Therefore, the directives have been implemented differently in each member state to an extent or another. Member states had a leeway for regulation. A lack of harmonization has been found that it stifles innovation and it prevents the free flow of personal data throughout the Union. And it also led to different levels of protection for data subjects. And that's why in 2016, the General Data Protection Regulation, the so-called GDPR, has been adopted and which has entered into force in 2018. It being a regulation, it means that it applies unitarily throughout the European Union, thus creating the desired level of harmonization. Furthermore, the GDPR provides an updated data protection framework in line with technological advancements. For example, it provides rules on automated decision making while remaining at the same time technologically neutral. Therefore, the GDPR is the EU-wide legal standard for the protection of personal data, and it is also believed and considered to be the one that provides the highest level of protection in the world. Now we will take a look at the GDPR's scope of application. And we will consider both the GDPR's territorial scope and its material scope of application. In order to provide a sufficient level of protection, the GDPR has a wide scope. Territory-wise, it applies to organizations which are registered or domiciled in the EU and which process personal data. It also applies to non-EU organizations and which have an establishment in the European Union, provided that the processing takes place in the context of their activities. For example, a company having a sales office in the EU would have to comply with the GDPR if the processing takes place in the context of that office's activities, sales activities in the European Union. The GDPR applies regardless of the legal form of that establishment. For example, it can be a branch, it can be a subsidiary, it can have legal personality or not. Then the GDPR also governs the processing of data by non-EU organization, irrespective of whether that processing is taking place, if it refers to the monitoring or targeting of individuals which are located in the European Union, or if it refers to the offering of goods or services to individuals in the EU. Now, for example, having a website, simply having a non-EU website accessible by Europeans doesn't mean that the organization will become subject to the GDPR. However, if Europeans can purchase the goods or the services from the EU, then the non-EU organization will become subject to the GDPR and will have to comply with all the obligations thereunder. Moving on, we will discuss the GDPR's material scope, which is quite intuitive, as the GDPR applies to the processing of personal data through automated means. Personal data is defined as by the GDPR as any information that can lead to the identification of an individual, either directly or indirectly, for example, by using additional identifiers such as IP addresses, location, cookie identifiers, so on and so forth. For example, if you have my name, that is personal data. Also, if you have my number, that is personal data, including my IP address. So personal data will be deemed as information will be deemed as personal data under the GDPR, even if it doesn't lead directly to the identification of a person. For example, if you have one data set and then you merge that data set with an additional data set acquired from a third party, and that linkage results to the identification of a person, all this data processed in this way leading to the identification will be considered personal data. This leads us to the distinction between pseudonymized data and anonymous data, which is a very important distinction given that pseudonymized data is still personal data and thus governed by the GDPR, whereas anonymized data is no longer subject to the GDPR. Pseudonymized data is data which has been separated from its direct identifiers and which could lead to the identification of a person only with the help of additional information which is kept separate. For example, the identifiers in personal data sets are replaced with pseudonyms, and the document linking the pseudonyms with the identifiers is kept under the authority and supervision of a different department of a company than the one that is doing the processing. Pseudonymization is very important technique under the GDPR, and the GDPR provides certain incentives for the use of this measure. Pseudonymization helps controllers comply with their security requirements. Also, pseudonymization can allow for the processing of personal data beyond the original purpose for which it has been collected under certain circumstances, it being deemed an appropriate safeguard for personal data, and it is also considered a measure which helps controllers comply with the privacy by design principles. Now, anonymized data is information which has been separated by its identifiers in an irretrievable way, which means that the data subjects will no longer be identified, not even by matching that data set with additional information. So data remains anonymous if there are no reasons, if there are no measures reasonably likely to be used to lead to the re-identification of the person. The reasonably likely to be used threshold is a moving target, as it shall be determined whether these means exist based on the time and cost required for re-identification, based on the state of the art in technology, and based on technological advancements. This means that what can be deemed anonymous today, it may no longer be so tomorrow. For example, in 2016, Netflix has released 100 million records of anonymized data, which included users' movie ratings. After the data has been made public, two researchers were able to re-identify a considerable number of individuals by matching the anonymous data with ratings made by data subjects on other websites such as imdb.com. It is very difficult nowadays to really anonymize data, considering that now data sets are highly dimensional and they contain many data subjects attributes, and it is very difficult for those attributes not to lead to the identification of a person when that data, for example, is linked with additional data sets such as public data sets, as exemplified in the Netflix case. So a careful assessment should be made. Furthermore, it is also important to consider this when selling data to third parties. When selling the anonymous data, one would have to take into account that in the hands of third parties, that personal data, that anonymous data may still be and may still be considered personal data. So we will now move on to the key principles for personal data processing, which are provided for under Article 5 of the GDPR. The first principle is the one that requires that the processing to be made in a lawful, fair, and transparent manner. We will discuss this principle in more detail in the second part of the GDPR course. However, the lawfulness and the fairness is mainly achieved when the controller has identified one legal basis appropriate for the processing of that data, such as consent or legitimate interest. Then the GDPR provides for the purpose limitation principle, which states that personal data should be collected and used only for the purposes which were disclosed to the data subject upon the collection, and processing data beyond that initial purpose normally is not allowed and should not be done. The third principle is the data minimization principle, which means that controllers should collect and process only personal data that is strictly required in order to achieve the disclosed purposes. Then the GDPR provides for the accuracy principles, which states that personal data should be accurate and where required it should be kept up to date. Then the storage limitation principle provides that data should be kept and processed only for as long as it is necessary to achieve the purposes for which the data was collected. Thereafter, the controller should basically either anonymize the data or delete the data. One example would be that of a marketing research agency, which should anonymize the data it has collected after completing the marketing research report. Then we have the integrity and confidentiality principle, which is a very important principle providing that controllers should implement and adopt appropriate security measures, protecting personal data against unlawful access or against accidental loss, destruction, or damage. This would be complied with, for example, by a cloud services provider if it adopts and implements appropriate security measures such as encryption, access control, or if it carries out recurrent security audits. Or otherwise testy security measures such as penetration testing, so on and so forth. Lastly, there is the accountability principle, which requires controllers to document how they comply with all the other 6 principles. So controllers should have in place records and documents evidencing the measures they have implemented. We will take a look again also in the second part of the course at all these measures that a company should normally have in place. So thank you. That was it for the first part, which was meant to provide a very broad overview of the GDPR, and we will go into more details in the second part.